Okay, let's go on the record. David, this is cause number 2021 CR 7662, the state of Texas versus Sarah Redgate. Attorneys, please make your announcements for the record.
Good morning, Your Honor. Joshua Luke Sandoval for the state of Texas.
Stephen Redgate here on behalf of the defendant, Your Honor.
Make sure that the TV is not, that the volume is on, please. Okay. For purposes of the record, Ms. Redgate is also appearing here in person. Go ahead and tell me your full name. Can you hear her, David? I can't hear you.
It's a little tough. They need to speak up.
Did you hear her now? Yes, okay. That microphone is really good, so it helps if you take your mask off. Ms. Redgate, originally we were on the record back on February 22nd. At that time, we went over the admonishment and you entered a plea of no contest. Shortly after, there was some commotion, and I think it was your mom, am I right? That was saying that you were innocent. And so that made me pause the proceedings and ask you to come in person today. For purposes of the record, before we got on the record, we also had the same mom of the defendant wanting to be heard by the court and was subsequently escorted out of the courtroom because she was at that point causing a disruption. I asked both attorneys if either of them wanted to speak to mom, and both responded there was no need to speak to mom. So now we're going to go forward with your plea. We're going to start all over because I want to make sure that you are absolutely clear on what we're doing and that what you're doing today is being done freely and voluntarily. Okay. All right. So it's, you've already seen these documents, but I'm going to show them to you again on the screen. You'll be able to see them on that side if you wanted to just turn for a little bit. But you've already seen these before. So Ms. Redgate, we're here because the state has filed a true bill of indictment alleging the offense of aggravated assault with a deadly weapon, alleged to have occurred March 26, 2021. Do you understand the charge that you have this morning?
Yes.
That is a second-degree felony, and it is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 2 and 20 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes.
Everything that I'm showing you on the screen, I've already gone over this with you before, but I'm just doing it over just to make sure we're clear. You have the right to a jury trial. You have the right to cross-examine or to confront the witnesses against you. You also have the right to remain silent. Those are your constitutional rights, Ms. Redgate. Do you understand those?
Yes.
When you sign that document that I have up there on the screen, what you're telling me is that you're going to give up those rights. Is that what you intend to do?
Yes.
Is this your electronic signature at the bottom of that screen?
Yes.
Are you a citizen of the United States?
Yes.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Ms. Redgate, are you satisfied with the representation of your attorney?
Yes.
Mr. Redgate, are you satisfied that your client has a rational and factual understanding of the proceedings against her?
Yes, Your Honor.
Has she been able to assist you in the preparation of any defenses?
Yes, she has, Your Honor.
And in your opinion, is she mentally competent to waive her rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver of rights and make it part of the record. Ms. Redgate, on the screen, I have the plea bargain that you made in this case. The plea bargain calls for a recommendation of 7 years deferred adjudication, $1,000 fine. The affirmative finding of a deadly weapon is deferred because this is a deferred application. The state is recommending deferred adjudication, and they will also dismiss a misdemeanor assault, family violence. Looks like a first. There is no agreement on the affirmative finding of family violence. We're going to do a TAP evaluation and 50 hours of community service. Other punishment recommendations include no harmful or injurious contact with Jennifer Schuster, no weapons, take medication as prescribed, substance abuse treatment if necessary, drug and alcohol screening, screening for anger management, mental health evaluation. Is that your understanding of the agreement?
Yes.
Mr. Redgate, is that yours?
That is my understanding of the agreement, Your Honor. However, we are asking the court to take into consideration that my client is not working at this time. She's being taken care of by her father, and we would ask that the fine be probated or abated.
And I spoke with Mr. Redgate about that yesterday. I have no objection to that request.
Is that otherwise your understanding, Mr. Sandoval?
It is, Your Honor.
Okay. Ms. Redgate, what is your plea to the charge of aggravated assault with a deadly weapon? Is it guilty, not guilty, or no contest?
No contest.
Are you entering this plea of no contest because you have talked about this matter with your attorney, and you do believe that entering this plea is in your best interest?
Yes, Your Honor.
And are you doing this freely and voluntarily?
Yes, Your Honor.
Has anyone forced you to enter this plea?
No, Your Honor.
Has anyone offered you anything in exchange for a plea?
No.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers exhibit number 1 into evidence.
No objection, Your Honor.
State's one is admitted. Mr. Redgate, are you satisfied the state complied with Article 3914?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. Give me just a few minutes to read the exhibit, please.
Yes.
With the dad right now, Your Honor. I'm sorry? Well, she's an adult right now, and she's he lives in a separate place with Sarah right now.
So not at 6020 Candy Cake.
I live there. She lives in the house as well.
Everybody lives here.
Yes.
You, mom, dad.
Yes.
I've conferred on Lloyd Brock, but I need to confer on Javon Christian, if I could.
Yes, sir.
I believe it's disclosed in that kindred.
Let's go back on the record. Mr. Redgate, are you, do you have any idea of what kind of medication your client is currently on or who her treating physician is?
Her father is here, Your Honor, and he can advise the court that.
Can I inquire? You can step forward, sir.
Get the search dog.
That's all right. You can come all the way up to the bench.
Right here, I can put a mic right here.
No, I want him in front. Mhm.
No, over here.
You can come on, that's fine. Okay.
Just speak.
What is the medication that your daughter takes? Who is treating her?
She's being treated at the Center for Healthcare Services.
Okay. And how often does she go there?
Right now, she's appointment every 3 months.
When was the last time she was seen there?
Her next appointment is in April, so probably about January.
She has an April appointment?
Yes, ma'am. Well, we got to make an appointment for her in April. Yes, ma'am.
And how are you at this point? I know she's an adult, but she's living in your house.
Yes, ma'am.
How are you ensuring that she takes her medicine?
I give her medicine.
You give it to her?
Yes, ma'am.
And have you seen a difference in her behavior when she's on the medicine as compared to when she's off?
She hasn't been off the medicine since the
This
incident.
happened?
Yes, ma'am.
I mean, she seems like she's a bright girl.
She's very bright.
I could tell.
Yes, ma'am.
Okay, so she's listening to you and following your
Oh, yes, ma'am.
instructions with regards to taking the medicine every day.
Yes, ma'am.
And how is the relationship between her and mom? I mean, are you all okay to live under the same household or?
Yes, ma'am. She talks with me most of the time. I tell her to listen to her mother. But as far as everything else, I intervene in anything. I have to listen to what her mother says. So if her mother tries talking to her, I run out wherever I am, listen to what she says.
Okay, do you work outside the home?
I'm working part-time. I retired from the VA and I'm working part-time. I just work usually 2 days a week.
Okay, and you're Robert Redgate, right?
Richard.
Richard.
Yes, ma'am.
There was an R somewhere, sorry. Okay. Is there anything else that you think I should know that would be helpful in structuring her deferred? I mean, she's going to be seeing somebody fairly regularly on
Yes, ma'am.
probation. So we're going to have a lot of contact with her.
Yes, ma'am.
Okay. All right. Thank you, sir.
Yes, ma'am.
Okay.
Thank you.
Have a seat. Did you hear what I told your dad, Ms. Redgate?
Yes, ma'am. Yes, ma'am.
So it sounds like as long as you take the medication that is prescribed to you, the correct dosage every day, it sounds like there's no problem, right?
Yes, ma'am.
But it's when you start to depart from that there's problems, right?
I think so, Your Honor.
I could tell you're a very smart girl.
Thank you, Your Honor.
So I know that you're going to understand what I'm about to tell you because you're getting a big break. You're going to be on deferred, but there's rules. And those rules apply to everyone who's on deferred. So when you become part of that group of people that are now under my supervision, because it's my court, my supervision, you're going to have to follow my rules. And if you don't follow my rules, there is a possibility that you could end up in prison. That's how serious this is. So I don't want you to walk out of here not being impressed upon you that you have to follow the rules. And if you don't, I'm going to know right away. Right away. A lot of the time in my day is spent reading violations for people who are on probation, people who don't show up, don't call in, decide they don't want to take a UA, decide they don't want to bother with probation. I know right away. And the only thing I can do when I get those reports is to get your attention. And I prefer not to get people's attention by sending an officer to arrest you. I prefer that you just comply with the rules. That's my preference. So I am going to find that the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. I'm going to grant the application for deferred adjudication. I'm going to do 5 years. I'm not going to do 7. I think if you're not going to follow probation rules, I'm going to know pretty quickly. I don't need 7 years to figure that out. 5 years is sufficient. The $1,000 fine is fully probated. The state is going to dismiss JN's 2007811. The affirmative finding of deadly weapon and family violence is held in abeyance. This is deferred. We're going to do a TAP evaluation, DDRF, and mixed supervision evaluation. The 50 hours of community service are held in abeyance. I want to see the results of the DDRF. No harmful or injurious contact with Jennifer Schuster. No weapons is a normal condition of your probation. You're prohibited from possessing weapons. Is there any weapons in the house? Any guns, any firearms? Not that you know of? Well, you are prohibited from possessing those. You understand?
Yes, ma'am.
As a condition of your probation, I'm going to order that you continue to take your medication and that you continue to see the Center for Healthcare Services and follow all of their treatment recommendations. I want her to be seen in person every 2 weeks to check on the status of her medication until I have an answer on whether she's going to be admitted for mixed supervision. It might take a few months of you being seen in person every 2 weeks, but we'll get you to the correct supervisor that's going to be very invested in you taking your medication. That's what they do. That's what that unit does. They're very good. This is a plea bargain case, Ms. Redgate. I followed your plea bargain agreement, so you do not have a right to appeal. Do you understand?
Yes, Your Honor.
So what are you going to do now that you're on probation? You're going to follow what?
The rules.
That's right. You're going to follow the rules. Thank you. Have a seat in the front row. My probation officer is going to talk to you. And Dad, you're welcome to sit there with her in the front row if you have any questions.
May I be excused, Your Honor?
Yes, Mr. Redgate, thank you.
Thank you.
Yes. Don't forget the dismissal, Josh. Josh is on his way back up. For those of you who want to confer with him, he'll get on Zoom in just a little bit.
Shannon,
Yes, ma'am.
Judge, myself and Shannon Locke regarding Lloyd Brock.
Just
we
a
do need-
minute.
Okay.
Just a minute, please. Okay, on what is the issue on Lloyd Brock?
We do need a trial setting, Your Honor.
And everyone, thank you for your patience. Brenda, we have a lot of, I'm being invited to a lot of breakout groups today.
It has to be in March.
Yes, ma'am.
If we could do March 21st instead of the 14th, Your Honor.
We sure can. That's the day I was going to give you.
You should just tell me it's a favor, make me feel better.
It is all to accommodate you, Shannon.
Thank you very much, Your Honor. I really appreciate it.
That's only because the 14th is already jam-packed.
I know.
So, no, but
And Your Honor,
321.
I also have Javon Christian. I'm a little bit jammed up this morning. I have an 11 o'clock federal court hearing, and I'm in like 3 other courts.
Do you want to come back at 1:30 to confer with Josh?
I do. Yes, please.
How come there's people in the waiting room? How come they haven't been let in, Ash?
Okay.
Are
And
they
I have to go to the
witnesses or
187th,
what?
Your Honor.
Go ahead. I'll see you back here at 1:30. Tell your client to be back here at 1:30. We'll send you the link.
Judge, all those people are witnesses. They're in there whenever we're ready for them.
Okay. Any other announcements? Does anybody
Judge, I'm
else
here
have
for
an announcement?
Martin Leal.
Yes. Go ahead.
We have a trial setting. We're ready.
Whose case is that? Is that Josh?
No, Judge, that's mine. I didn't see Mr. Cantrell in there. He's previously rejected an offer. Mr. Cantrell, would you like to confer, or you want to keep it as a trial setting?
I can certainly confer, but I think unless you're coming off let's confer.
Okay.
If not, we're going to set it for trial 328.
Yes, ma'am.
Judge, I'm already set for trial on that day in Guadalupe County.
321. You want 314? I mean, it's an old case.
Understood. Can you go into April?
Not very likely. We already have a lot of old cases in April. Go ahead and confirm and then come back and tell me if you're ready for
Will
a
do.
trial setting.
Thank you.
Anyone else need to announce?
Judge, I think you wanted to talk to us to Melissa Christian and I about Kyle Phillips.
I do. I can accomplish that with the phone call at lunchtime. I don't want to hold you guys up.
Oh, okay.
But I will definitely give you a trial setting. Let's keep it on for May 2nd for now. That I need the state to act on it once they get the mitigation stuff. Okay, I'll call you guys at lunch.
Great. Thank you, Judge.
Thank
May we
you.
be excused? And may our
Yes.
client. May our
Yes,
client be taken back. Thank you.
Mhm.
Your Honor,
Anyone else?
yes, Your Honor,
Yes.
on Mr. Anthony Johnson, I've conferred with him, I'm done with him for today. And also I've conferred with the prosecutors, the first setting case, and there's some other issues that are may come up, may arise. And so I'm thinking we're just going to need a reset on that case.
May 9th.
I was just appointed to that case. And then I'm waiting to speak with Josh on Brian Bellingary, but there was an issue that I wanted to bring to your attention, probably in the breakout room with you.
Okay. Go ahead and talk to Josh first.
Very good. Thank you.
Yes, so in my breakout room, if I could please have Ms. Christian, Ms. Hunsinger, Mr. Hancock, Mr. Marshall, and Mr. Locke.
Shannon is coming back at 1:30, Josh, to talk to you. He had to run to federal court.
Perfectly fine.
Are we ready on Joey's Cordova, Mario Cordova?
Yes, I was
You
trying
ready
to
on that?
cut in, Judge, to let you know we're ready to proceed to sentencing.
Did you review the results of the tap with him?
We
Joey?
did. Yes, ma'am, Your Honor, we discussed it.
Did William Defer get on? It's done. Mhm. Eric Emmons still on? Eric, Melinda, did you send me the PR bond? Did you get a hold of anybody?
I did, Judge. I sent it to you. You should have it in your email. If you don't, let me know and I'll resend it.
I have it.
Your Honor, this is William Defer and I am on.
Okay, thank you. We're waiting for your attorney. He's in another court.
Judge, this is Anna. Mr. Cantrell was being called in. I believe he's out of county in Guadalupe or Comal. I can't remember which he said right now. He said he would be back on at 1:30 this afternoon to confer with his client on some new thing. So we may have movement, we may have not, or not have any at the moment, Judge.
Mr. Leal. Can you come, you need to log back on at 1:30 so that your attorney can communicate with you what the offer is. We'll see you at 1:30, Mr. Leal. All right, let's go on the record on Cordova. After that, I have Jason Rodriguez. And Derek, I'm going to be reading while I'm working.
All right, thank you, Judge. I'll just hang out. Let me know when you're ready.
Thanks. Let's go on the record. This is cause number 2022 CR 0060, the state of Texas versus Mario Cordova. Attorneys, please make your announcements for the record.
Yes, Your Honor. Luis Echeverria for the state of Texas.
Morning, Your Honor. Joey Contreras for the defense.
Mr. Cordova is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, sir.
Mario Cordova.
Luis, I don't have a dismissal on the case that's being TIC'd. I
Yes,
already
Your Honor.
checked.
Yes, Judge, let me do that right now. And Your Honor,
All right.
Okay, go ahead.
This
Sorry,
is
Judge.
a recommendation. This is 6/6 recommended community supervision. We were waiting on the results of the TAP evaluation. It does recommend residential treatment. And I believe that's part of the plea bargain agreement. Does either side want to be heard on that issue?
We just want to add that it sounds like everyone's in agreement that that's what's best for him, Judge.
Yes, it is. And I'm very familiar with Mr. Cordova. And I think I've already expressed to him my concern for him picking up another DWI. So I'm just making sure. Yeah. So we did, just for purposes of the record, we did, as part of the plea bargain agreement, order a TAP evaluation and DDRF evaluation. The DDRF evaluation did come back. Mr. Cordova did not meet the criteria for the target population. However, the TAP evaluation indicates that he is a good candidate for residential treatment. And it is an above the line agreement. Okay, so anything further from either side?
Nothing from the state, Your Honor, and the dismissal judge should be with you in about 30 seconds.
Your Honor, my client is aware that he's going to have to wait for a bed, and he asked that bond be set so he could be out on bond while he waits a bed. I'm just passing that along to the court. If the court will consider that.
Yeah, no, that's denied. He's gonna wait. I do want him, however, to try lifetime recovery residential probation. I think that is the fastest way to get him into a residential program. And I need that to be for a minimum of 90 days.
Okay, lifetime recovery. Okay, Judge. Very good.
All right, Mr. Cordova, on January 13th, 2022, I accepted your plea of guilty to the offense of driving while intoxicated, third or more offense. I do find you guilty. I will assess punishment at 6 years confinement. That is suspended. You are going to be placed on probation for 6 years, $1,000 fine. There is 2 different sets of restitution. One is for $60 and the other one is for $57 for both the blood analysis and the drug analysis in the case that's being dismissed. 200 hours community service, no contact order with Zoe Templeton, 10 days in the Bexar County Jail. As part of your conditions, we're going to do residential treatment with lifetime recovery. DWI intervention, VIP, ignition interlock for 3 years. I want to see him in person for a compliance hearing 60 days after he's released from lifetime recovery. Mr. Cordova, this is a plea bargain case. I followed your plea bargain agreement. You do not have a right to appeal. Do you understand, sir?
Yes, Your Honor. And also for the no contact, they told me they changed that because they should put some money on my books and stuff like that.
I don't know who changed that, but I haven't changed that. So state, if you have any information on whether or not that should be changed, what is the contact that you need to have with her?
Just the no.
Are you in
contact.
my question is, are you in a relationship with her?
Yes.
State.
Let me check on it real quick here. I'm checking the notes, Judge, to see if there's anything regarding that. I don't see anything, Your Honor, on that point regarding a change in the no contact.
Your probation officer can help you with that once you meet with your probation officer, Mr. Cordova.
Yes,
I will
ma'am.
certainly change it if there's information from her that she wants it changed.
Okay,
That's not a problem.
thank you, Judge.
It'll stay like this for now. Thank you, sir. Good luck to you. Thank you, Mr. Contreras. We'll see
Thank you for your careful consideration, Judge. Thank you. As
Oh,
always.
you're welcome. Thanks.
May I speak to my attorney, Your Honor?
Yes, yes. You ready? I have several ahead of you, don't worry. Are we ready on Jason Rodriguez?
I'll be ready in just 1 minute, Judge. I just make a quick announcement.
Go ahead.
Judge, can I jump in and apprise the court of what's going on in Gerardo Vargas?
Yes.
So I have conferred briefly with Josh. I need to get up there and see the CPS records. However, there are still, if you will recall, there were counseling records that were in Spanish, and those are still being translated.
I'm ready when you are, Judge.
What is the status of the translation?
He said he would check on that for me. I don't think he was aware of that.
Yeah, you were dealing with Samuel on
Correct.
this one, right?
Yes.
Yeah. How about if I appoint David Garcia to translate this for you? You might not.
I don't know if I have his contact information.
All right, let me set this for, you know, it pains me to reset this case. It pains me. It's so old. Let's do March 28th for status on those counseling records.
Yes, ma'am.
And then I'll give you a trial setting if you have everything done, but I won't reset it past the 28th for counseling records. I'm just going to give you a trial setting that day.
Okay, that sounds great.
Okay, thank
May
you.
we be excused?
Yes, ma'am.
Okay, thanks.
Your Honor, we have an announcement on Skipworth if you'd like it.
Hang on. Yes, ma'am.
I've emailed Dr. Fabian in the interim, and I've not heard back from him on a date he expects a report to be completed. We've conferred with Josh. We just need to wait on that report. My guess is a couple weeks. Might be safe.
Let's do April 25th, please.
All right.
And please alert Dr. Fabian that he is ordered to have it before then.
I will. I will tell him the court has so ordered. I don't want to treat him. I don't want to treat him like my expert, but I will tell him as such. I don't think that's. I don't think it's going to be an issue, Your Honor.
I think that's plenty of time. I know his reports are very long and very detailed, and I appreciate them and I read them all, but we got to move it.
Okay. Thank you. May we be excused?
Yes, ma'am. Thank you. Who are the witnesses here for? For defer? Okay. Well, Raymond's not here, so. On Jason Rodriguez, you ready, Orlando?
Yes, Judge.
Did you go over the results with him?
I have not spoken to him in regards to the TAP, although we previously discussed the possible need for treatment. There are some issues in regards to his health that I need to discuss with the court in regards to whether we do something alternative or to hold it in abeyance until he's treated with his health condition.
What is the health condition?
He's got a broken leg that is, I believe, needs to be treated. I don't believe it's been set.
Oh, yeah, I remember that. I'm not sure that that will disqualify him medically. I think he's still good to go.
Well, I mean, okay. I guess we could just ask him about it in regards to what treatment he's in need of.
Well, we had a hearing, remember? We had a hearing on bond reduction where that
No,
was.
we
an
didn't have a
issue.
hearing. I had asked you I inquired about one and you said you ordered a PR bond report and we never had a hearing on it though.
I thought we had a hearing because you told me he wasn't getting the medical attention he needed at the jail for the broken leg.
I did bring it to your attention, but we
Yeah.
did not have a hearing, Judge.
Oh, okay. I do remember the part where you told me he had a broken leg and I wanted to inquire about why they hadn't treated it. Let's go on the record then. We can hammer out those details on the record.
Yes, Judge.
Where's David? This is cause number 2021 CR 6205. That's the evading arrest. 2021 CR 10113, ag assault with a deadly weapon, and 2021 CR 10114, violation of bond or protective order. But I think we're actually proceeding on count 2 in that indictment, assault of a pregnant person. All of those cases are the state of Texas versus Jason Rodriguez. Attorneys, please make your announcements for the record.
Travis Rodriguez for the state of Texas.
Orlando Gastagnon for defense.
Mr. Rodriguez is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, sir.
Jeremiah Rodriguez Jr.
Okay. This is a recommendation of deferred adjudication. We reset the matter for a TAP evaluation. Hang on, my system froze, hold on. Mr. Castañon, do you want to address the court about the results of the pre-sentence investigation report and the TAP evaluation?
I do, Judge. I just want to address there were 2 recommendations that if he didn't go to SATF, that he be sent to intensive outpatient, I believe is what I saw. He does have a medical condition that I believe needs to be treated. He has a broken leg, and I believe that he's still enduring pain and needs, I believe, that to be set. You froze, or I froze.
No. So for purposes of the record, the dual diagnosis residential felony facility results were that he did not meet the target population for that type of structure. However, he did meet criteria to be sent to the to SATF, to the residential treatment facility. And what I would like to do, Mr. Castañon, is I want to see what the results of the medical screening are, because he does have to pass the medical screening. And if for whatever reason they tell me he cannot go to SATF, I will ask them to send me a report and then we can reconvene. But for purposes of sentencing, I'm going to sentence him today. And I'm going to order the SATF facility. If he medically is not accepted, then we will revisit that issue. But for now, because of the number of felonies and the facts in all of those, I will follow the recommendation of the state, but only if there's a structured treatment facility for him. And that's what I'm going to do. So, Mr. Rodriguez, you're going to be medically screened to see if you qualify to enter that treatment facility. And if they tell me that you don't qualify, then we're gonna have to come back and revisit. Or I might just order the intensive outpatient once I get that report. So,
Excuse me, ma'am.
yes.
I had just did an X-ray here in the medical, and it shows that my bone is still broken.
Yeah. Your bone is actually going to show broken for several months because it takes probably 3 to 6 months for it to show not broken. My
And for
son broke a
some-
leg last year. I know.
For some reason, they actually, they took away my crutches and they took me out of the medical part. But
Yeah. So I will know, I will have an idea of what we're going to do. But for today, I'm going to order status. So on cause number 2021 CR 6205, I do find the evidence is sufficient to substantiate your guilt, and I will make no other findings. I'm going to grant the application for deferred adjudication for a period of 6 years. There's a $1,000 fine. This matter will run concurrent with 2021 CR 10113 and 10114. I apologize. It's not 114. 114 is actually going to be dismissed. Nope, that's wrong. I was right the first time. It is 10114. It'll run concurrent. The state is going to dismiss 2 misdemeanors. It looks like. Is that right, state?
No, Your Honor, I think that the misdemeanors are going to be concurrent and there's 1 felony to be dismissed.
Yes, the drug case is going to get dismissed. You're right. Yes.
And
So
I
it runs
have,
concurrent. It also runs concurrent with 660-953, 668-719. 200 hours of community service. I'm going to hold those in abeyance. I need to see what's happening with treatment. As part of the conditions of probation, I'm going to order SATIF. If he medically is disqualified from attending SATIF, I need to know right away. We'll know, Mr. Castañon, that usually will happen in the next 2 weeks. That's how quick that is.
Yes, Judge.
It wouldn't be, normally it's not longer than 2 weeks. They tell us right away. So with regards to this case number, I do find that this is a plea bargain case and you do not, I followed the plea bargain agreement. You do not have a right to appeal this case, Mr. Rodriguez. Do you understand?
yes, ma'am.
Okay, with regards to the ag assault deadly weapon, I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. I will grant the application for deferred for a period of 6 years. In this matter, there is also a $1,000 fine. The affirmative finding of deadly weapon is going to be held in abeyance. This will run concurrent with 2021 CR 10114 and 2021 CR 6205 and the misdemeanors as well. The state will dismiss the drug charge, the 2021 CR 10719. Same conditions of SATIF, same condition to hold the 200 hours in abeyance. In this case, there's a no contact order with Angelina Corina Vargas until the Batterers Intervention Prevention Program and parenting classes are completed. So the BIPP is part of this case. He has to complete that. I'm going to hold the moral recognition therapy class in abeyance. I need him to focus on treatment. This is a plea bargain case. I did follow the plea bargain agreement. You do not have a right to appeal this case. With regards to count 2 of cause number 2021 CR 10114, I do find the evidence is sufficient to substantiate your guilt, and I will make no other findings at this time. I'm going to grant the application for deferred adjudication for a period of 6 years. And these conditions are actually going to be the exact same conditions as the ag assault deadly weapon. So $1,000 fine. The affirmative finding of family violence is held in abeyance. Same cases to run concurrent. Same no contact until the BIP and the parenting classes are completed. And the community service hours and the moral recognition therapy course is held in abeyance. Same condition of SATIF. This too is a plea bargain case, Mr. Rodriguez. I followed the plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes, ma'am.
Listen, this is the bottom line for me. Treatment. We need to get you on the right path, and treatment's going to be the solution. So if it's not residential, I'm going to find a structure that's going to work, because you cannot be without structure. These are too many cases, and they were not nice. There was weapons, you fired a gun. I mean, we can't not have structure. We need structure and we need treatment. So that's what's important to me. So you're going to get screened medically. If you qualify, great. SATIF is a great program. And if you don't qualify medically, I'm going to find something, but we're going to get you some treatment. Do you understand?
I have a few questions.
Yes, sir.
So let's say let's say if I do qualify for the status, when does my probation actually begin? When I get there?
After you finish your residential treatment.
Yes, ma'am. And so the whole time I'm there and the whole time that I've been here, that's just dead time?
It's not dead time, because if you ever get revoked, all of that time counts towards your sentence. But because this is deferred, you have to wait for a bed there, yeah.
Yes, ma'am. Also, I did go up for my PR bond last month.
I got it. I did get it, but I'm sentencing you now. And so if
there's no way to get a bond in the meantime,
I'm not going to release you until I know what I'm doing with treatment. I'm not doing that.
Yes, ma'am.
Because at this point I've already sentenced you. So if SATIF doesn't work, I'm going to find something else and you'll be released to something else. Anything else?
There's outpatient facilities if SATIF is not.
Outpatient is an option, but I'm going to find out about residential first.
Okay. Yes, ma'am.
Go ahead and go into the breakout room.
Yes, ma'am.
Thank you, Mr. Castañon. You're excused.
Thank you, Judge.
Ray Martinez, if he's on with defer.
I'm going to, I need a break. I need to make some notes and then I'll be ready on defer. You have witnesses, right?
Yeah. Oh, he's down there, yeah.
Okay.
Ray, if you would like me to come down and confer on John Munoz with you real quick, I can do that.
He said yes.
Okay, thanks. I couldn't hear you. I'll be right down.
And Your Honor, if and when you're preparing for William defer, Luis is on his way down to the courtroom as we speak.
No problem. Thank you.
Ashley, Robert Featherston here. Is the PSI on Mr. Alejos at the office? I'm in the building.
I believe it's with the judge, Robert, and it should have been emailed to you, but she had something that she needed to speak to you about that.
Is she in the building or do you want me to do it on Zoom?
Judge and our CLO are in building.
Okay, I'll be right over to the courthouse. I mean, to the
What
courtroom.
case is that?
Mr. Alejos, 21 CR 1.
I didn't have to talk to him, Ashley.
Oh, I thought you did, Judge. I
No.
thought you mentioned it earlier on him.
Was
No, I don't have
going-
anything.
It was probably for the woodshed.
No, I'm ready on Alejos. I don't have anything to, I just need to, I'm going to take a break because I need to update a few things and I need to read the PR bond. In fact, Derek, can I see you in the breakout room?
Mr. Featherston, they're all there if you're going to head down.
Okay, I'll be right over to look at that PSI.
John, how you doing, sir? Hey, how are you? Good.
Ashley, are you there?
Yes.
On Mr. Johnson, I don't know if I informed the court, but I'm done with him. So I don't know if he's still there or what have you, but we're just going to need a reset on Mr. Johnson's case.
I believe judge gave you 5-9. He was sent back already.
Okay. Okay. 5-9. And then on Mr. Bellingary, we have not talked with the judge yet about that, but I have talked with the prosecutor about that. It still is going to be a trial, but I need to speak with the judge concerning a secondary matter regarding that. We're likely going to need a special setting as well because the state has out-of-state witnesses.
Judge stepped away from the bench. She'll be back on to give you an announcement or take your announcement. I'm sorry.
And you said May 9th on Johnson?
Yes, sir.
Thank you.
Did you get the appointment?
Yes, it did come through. It did come through.
Awesome. Thank you.